I'm joined by my partner and colleague,
This meeting is being recorded.
and we'd like to welcome you to this morning's webinar on updates around the Affordable Care Act and some key compliance issues. We appreciate your taking some time with us this morning to cover what appears to be a never-ending litany of compliance challenges for employers and plan sponsors. And we're going to use the hour that we have today to really talk about some of these emerging issues that we thought were important for employers and plan sponsors to be thinking about as we head into the fall. As is always the case, this webinar is being recorded, and it will ultimately be emailed out and distributed to our clients and constituents in the event you've got a colleague or an associate that was not able to participate today. We do think this will be one where your associates and others in the organization involved in the benefits will certainly want to have an opportunity to listen and review the content. So about today's discussion in particular, health and welfare plan rules continue to be updated, continue to be changed, continue to be at the forefront as a result of the COVID-19 pandemic. Lots of updates have happened. There have been all sorts of rules and changes, and it has been difficult for employers and plan sponsors to keep up with them. The goal of today's session is to revisit these things to make sure employers know the things they need to be looking at. So, for example, what does the public health emergency mean, and what's the outbreak period mean? Frankly, these are terms that we hear on television or might read in the newspaper, but they have important practical application for benefit plans. Plan design changes, issues around coverage, dealing with the complexities of premium refunds. Sometimes premium refunds fall into the category of no good deed goes unpunished as it relates to the proper handling of premium refunds. There, of course, have been some updates to the Affordable Care Act, lots of things and moving parts with respect to COBRA, HIPAA, and cafeteria plan updates, and then last but not least, some other general compliance updates that we think employers and plan sponsors need to be looking at. And as we always cover, yes, the material will be shared with any registered participant. And this presentation is one of those where when you get it, you should print it because it will give you a step-by-step set of things that you might need to be thinking about from a guidance perspective. So a little bit about the overview of 2020, the year that continues to be complicated and difficult for us all. I'd be remiss if I didn't take a moment and say we certainly hope that all of our clients and constituents are dealing with this crisis as best they can. We know it's impacted people personally, it's impacted people's businesses, and all of us are doing everything we all respectively can to get through what has been a challenging time. But for sure, the industry has changed considerably since March. And this discussion obviously is speaking from a benefit perspective, not how it feels like the entire world has changed since March, but frankly, government agencies and carriers and health plans, many temporary policies needed to be adopted to navigate us through, from a lawful and a compliance perspective, issues with the emergency, issues with the pandemic. We're monitoring these things. More importantly, please continue to check our website where we have bundled together a host of resources that are kept up to date and fresh around the impact of COVID, both from an employee benefit perspective and frankly from a property and casualty point of view. We are monitoring all of these issues and how it impacts whether it's benefits or commercial insurance. And frankly, as emerging things come up, we've had to issue a whole number of urgent email and regulatory alerts, and we will continue to do that. So as things change and emerge, we'll continue to get them. They're all at our resource center. So just a friendly reminder, all this information is always available at your fingertips. So while things have changed since March, regrettably, we suspect and have empirical reason to believe that things will continue to change, principally as a result of the pandemic. We're following these things, but there is more on the horizon. So it is very likely that the Congress will act on another set of responses to the pandemic, which could very well address employee benefit issues. So, for example, might they ultimately provide economic relief around COBRA subsidies? Could that make the next bill that the President and the Congress are going back and forth over? There could be continued initiatives around the federal paid leave and granting continued extensions and accommodations as a result of the things that we're dealing with. The issue of taxing employee benefits continues to gain more momentum as to whether or not all of the tax exemptions that exist today, will they be maintained? Will they be changed? That's certainly up in the air. And with the advent of the presidential election, there's been a lot of conversation about the reemergence of, quote, a public option, which was debated during the Affordable Care Act years, or even a program like Medicare for All. These are topics that will continue to be debated and will be front and center. And it does not appear as if the debate on healthcare is going away anytime soon. There could be changes. In fact, we hope that there may be for employers and plan sponsors around the onerous requirements from a reporting perspective with the ACA, or other mandates that could be baked into the ACA. And of course, many of you have seen, although it's unclear what the impact will be, what might happen with some of the executive orders the president is taking to attempt to deal with drug costs. A lot of those actions have been more oriented toward Medicare, but they could have a spillover effect to employers. So we're watching all of these things, and many of them are unfolding real time. So I mentioned at the beginning this notion of the PHE, as it's referred to, or the public health emergency. And with all the things that are happening, these declarations of a public health emergency, some may just believe, well, we're in a public health emergency and it's been declared as such. But there is real regulatory meaning and consequences as a result of the public health emergency. So the original public health emergency was set to expire back in July. Well, now that's been extended again through at least October 23rd, and perhaps could be extended again. This declaration is important because it enables the government, as you can see here on this slide, to offer benefits and certain relief to companies that are suffering from the effects of COVID. It is very analogous to when there is a terrible storm and an area is declared a state of emergency. It gives the executive, be a governor or a president, broad authority to issue more resources, to release more funds. This is the public health emergency aspect of that has, in essence, given the government the lawful capacity to do some of the things that they've done. So, for example, employee benefit and health coverage plans that have received some form of financial or compliance help, things like what was the Families First Corona Response Act, the Relief and Economic Security, or the CARES Act. There have been changes around deadlines to HIPAA and to COBRA, and when notices need to be delayed. All of those things were able to happen, and employers able to get those benefits because of the declaration of the public health emergency. So that's the important meaning of why the public health emergency matters. And later in the presentation, my colleague Phyllis Saraceni is going to talk about this in a little bit more detail and other related pieces. So, some new laws. Some of this you may have already seen or can recollect. March seems like a lifetime ago, so it was important that we revisit these things. So the first piece of federal relief, the FFCRA, that was the bill that was the very first that was signed very quickly on March the 18th. It gave paid leave, expanded paid leave as a result of COVID. It gave health plan coverage continuation requirements during special situations for people with special paid leave. And this was the law that said that COVID testing happens without a member cost share, copay, deductible, coinsurance, so that there wouldn't be concerns about barriers to being tested. Later on the 27th, the CARES Act further extended that, and it broadened the coverage requirements for testing. It did provide some very helpful relief in that for plans that had high deductible health plans needing telemedicine, that the obligation for non-preventative services having to first meet the deductible was waived, made telehealth much more available to participants. We hope that maybe that becomes permanent. Back at that time, it was uncertain when a vaccine would be available, but clearly the law addressed how coverage will ultimately work when a vaccine comes out. And then there were some new rules and issues around qualifying expenses under a health savings, health reimbursement, or a health FSA account. You can see in the bullets below, there was extension or relief granted around Section 125 plans, lots of guidance, notices. That's sort of a summary of the headlines of things. But these two laws laid out the initial groundwork for extending leave and laying out how coverage is needed to happen. So to dig into that detail, because we think it's important that employers and plan sponsors continue to be focused on making sure their plans are set up properly, we're going to get into some of the further detail in the weeds. So during the public health emergency, which is important, it continues. Health plans must cover COVID-19 testing without cost share. So co-payment, co-insurance, et cetera, it applies to all employer-sponsored plans. Whether you are a fully insured plan, whether you're a self-funded plan, all plans, they cannot, as you see here, apply deductibles, co-payments. There can't be a prior authorization. There can't be medical necessity. They simply need to be paid under the benefit plan. And they must include items and services, as you can see, that are normally provided during a healthcare visit. This even includes the telemedicine piece. So a group health plan, obviously all the participants on this call are either with an employer plan or perhaps a multiple employer welfare kind of an arrangement, but group plans have to cover the approved COVID-19 testing, along with all of the items that come along with the visit, the things that happen during the normal handling of how a test may be provided. And you can see in terms of next steps, by now, we believe employers and plan sponsors have done this, but the key is continuing to make sure these are covered without cost share. So health savings accounts, qualifying high deductible health plans and so forth, how does this work? Well, generally, in order to qualify as an HSA, qualified high deductible health plan, other than preventive care, services are first subject to a deductible. And so, generally speaking, absent these new special rules, there could have been prohibitions for people with respect to COVID. So, under the special rules, you can have under a qualified high deductible health plan with an HSA, you can pay for the COVID-19 testing and the treatment without having to worry about the deductible. It allows the same thing to happen with telemedicine programs again. And these changes were retroactive to January of this year and obviously effective for plan years beginning, as you can see here, in 2022. Employers can choose under their design from an HSA qualifying plan to provide coverage for COVID-19 testing and the test or the treatment at reduced or no cost without negatively impacting your HSA plan. That's the headline. Right? So the deductible, copay, all of those other things that have to first apply do not. An employer does, however, need to make sure that they amend their plan, that it specifically now addresses this. So that's an important takeaway at the right time that employers and plan sponsors need to be doing. So the vaccine, we've heard and have read vaccines may be coming. Who knows what that actual date will be, but ultimately, health plans must cover COVID-19 preventative services, including vaccines, once they are available and once they are approved by the FDA. So once they are out there and they are available, this will be a cost that employers must cover in their health plan. There's been no reliable information yet about what that might cost an employer. but there will be costs. This will be an expense that employers and plan sponsors are going to have to consider once more information becomes reliable. So, non-grandfathered plans must cover the recommended preventative services without cost sharing. Free coverage or preventative services for vaccines, generally speaking, again, as we talked about before, these preventative services like the tests and the vaccines are not going to have a member cost share that will be an obligation for them as a participant. Health plans usually have at least a year after new preventative services are recommended to cover. In this instance, it appears there are shorter deadlines, and as you can see, really important, plans must cover COVID-19 preventative services and the vaccines within 15 days after recommendation. So we can be assured when these things are ready, the regulators, the CDC, are going to be moving quickly, and within 15 days after they're approved, our plans will need to cover them without member cost share. We're tracking that closely because of the potential for cost impact for employers and plan sponsors. There were also some changes as it relates to eligible expenses under these HSA, HRA, Health FSA kind of plans. This one's real simple. This one is positive. Two things. So over-the-counter medications are now eligible expenses, as are products for menstrual care. Prior to this, they had been removed as being eligible expenses on a pre-tax basis. So the CARES Act removes that requirement that it only be prescription medications, which was a part of the ACA. So OTC medications are covered, and you can see here, similarly, as it relates to menstrual products, we've outlined what they are, and it applies to expenses incurred after the end of the last calendar year, and this is a permanent change. So this, we believe, for participants and for plan sponsors is a good thing. This was very unpopular when it was removed as eligible under the ACA. So changes are automatic. This is obviously a part of what's eligible in the code. Employers should be preparing and producing, certainly as things come back into normal, communication so that participants are aware that these are now eligible expenses. Again, for employers that are January plans, open enrollment is upon us. We know that will be an opportune time to re-educate and remind people of those things. So, MLR rebates, medical loss ratio rebates. So why are we talking about MLR rebates in the context of COVID-19? Well, a couple of reasons. First and foremost, the ACA continues to require that based on loss ratio for insured plans, that if a plan, be it large or small, there's different metrics, if more premiums are collected than claims paid at a certain medical loss ratio, that premium monies are to be returned to the employer and to the participant. So, well, how does that play into a pandemic? Well, let's think about what's been happening. We have seen a very steep decline in claim costs. Early on, people couldn't go to the doctor, they couldn't go to the hospital, and so claim costs dropped. Yet, fully insured carriers continue to collect premium. And so what we have seen is that carriers, to get ahead of this, have begun to issue rebates now. There are health plans that have given a 1-month premium reprieve. They've given a 20 or a 25% credit on a bill. It all sounds great. And frankly, it is favorable to the employer and the plan sponsor because of the situation. Frankly, some of the carriers have done this, in my view, to also make themselves look very good in the eyes of the public. We're giving you this money back. Look how wonderful we're being. Well, frankly, if they don't give it back now, they're going to give it back next year because they will have been below the ACA requirement. But putting all of that aside, the issuance of these rebates right now requires the employer to do something as it relates to how those monies get applied. So simply put, if an employer has a plan where the premium is $100 and the employer under their health plan pays $60, and the employee has a 40% or $40 payroll contribution, well, that MLR rebate has to be shared proportionately with the employee. Now, if the employer pays the whole premium, well, there's no monies to be shared. So what we have here is a requirement, which is not new, but it's becoming much more prevalent in the age of COVID, that if an employer gets rebate money back, health plan, disability plan, medical plan, pharmacy plan, any plan where the employer is paying premium and the participant is sharing, they have to share back as it relates to the distribution of those monies. So how does this work? Well, in essence, the dollars can be separated or can be distributed back to the employee in a couple of ways. First way is the value of the employee's portion could be used to enhance the benefit. Maybe you're going to waive co-payments for a certain service. Maybe you're going to make the generic copay on your pharmacy plan $5 as opposed to $15 for some period of time. The benefit can be enhanced. Another way, as is illustrated on this slide, is that future employee contributions could be reduced by the value of the rebate. A final way is that the employer, in my example, could give the person back a check for $40. That, in our judgment, is very complicated and brings in taxable consequences by having to pay the participant, not to mention the onerous administrative issues. So the employer cannot just maintain these rebates they're getting. There needs to be a pro rata share distribution with the participant where a participant shares in some of the dollars. This applies not only to ACA rebate issues, but COVID rebate issues as well, which we're seeing more and more of. So some changes to the new paid leave laws. And I'm going to cover some of these things at a macro level, again, really to make certain that employers and plan sponsors are truly aware of what all these issues mean, how they impact you, because when they came out in March and otherwise, they certainly came out with a fury. And that was also at a time when many businesses and employers were grappling with the immediate effects of the pandemic. So, new paid leave laws. Well, employers with fewer than 500 employees and government employers, they're subject to this new paid law. It was effective this past April. It runs as of now to the end of this year. And it really expanded FMLA. It provides up to 12 weeks of partially paid FMLA to care for a child whose school or place of care is closed. So obviously, in the early part of the pandemic, we have a new academic year that's just begun, still rather uncertain what will happen, but schools were closed, daycare was closed, families were forced with having to deal with this. This expanded the FMLA. And in addition, from a paid sick leave perspective, up to 80 hours of paid sick time for certain reasons, which of course included childcare, if you yourself had symptoms of COVID, or you were advised by a medical professional to quarantine, you had up to 80 hours. So this is a moving target because they could be adjusted again in a forthcoming law, but all of the information on this as it relates to changes that are forthcoming, we will continue to push out updates. This is what applies now on the paid leave law piece. So how does all this impact health coverage during the leave? So we talked about the paid leave requirement and how all of those things line up. It does have an impact, if you will, on health coverage. So health coverage must be maintained during the material, as we talked about on the prior page, as if the employee had continued to work. So what we talked about on the prior page on the leave issue impacts health coverages during those leaves. That's why that first slide a moment ago directly ties to this one. Same benefits and coverages must be maintained. Any plan changes that get made, they apply. And the employee, of course, has to make their normal contribution. So they continue to be responsible for whatever portion of premium they are sharing with you all to participate in your plans. The employee may choose to drop the coverage during the leave. Perhaps they can't make the contribution. They can drop the coverage during the leave. It, however, would need to be reinstated when they return to work. And coverage, of course, may end if the employee does not return to work after the FML leave. So this ties hand in hand with the paid leave requirements extending to the obligation on the healthcare side. So a few final items that I'll cover before I turn it over to Phyllis. There are other rules, as if what we haven't covered enough or yet is not enough. There are new rules for mid-year changes. So a general rule as it relates to mid-year changes, and many of you are fully aware this is benefit in HR professionals, elections for pre-tax benefits cannot be overturned or changed irrevocable during the plan year with limited exceptions. Right? There are qualifying life event conditions, if you will. Well, the new rule that was implemented through the pandemic modifies that. It does allow and applies to prospective elections. So now an employee may be allowed to make a mid-year change regardless of the rule around it being irrevocable. The new rules are temporary. They only apply as of now to this year. They obviously need to be communicated to participants. And of course, an employer plan sponsor has to amend their 125. So this was put into place to give allowances and flexibility for people to make mid-year changes if they needed to do so without the consequences that would normally be into effect. So what are the permitted changes? And these are optional. I want to really be clear on this. These are optional permitted changes. An employer may, and as a result of that, may not elect to do this. The rule gives an employer or plan sponsor the flexibility to do so. So the employer may amend its cafeteria plan to allow each employee who's eligible, as you can see here, to make salary contributions to make prospective election changes during the entire year. An employer may say, I don't want to do that. Or an employer may say, based on our circumstances, our business, our conditions, all of those things, we would adopt this. With respect to self-insured or fully insured employer-sponsored health plans, the employer may allow the employee, I'm going to come back with carrier approval, to do the following items that we'll run through. Excuse me. Make a new election, revoke an existing election, and make a new election to a different plan, including maybe you're dropping family coverage and going to single as a result of the economic consequences of the pandemic. Revoke existing elections, provided the employee attests in writing that the employee is enrolled or will enroll in other coverage not provided by this particular plan that you may have. So this gives the employer the ability to have flexibility to allow their workforce to make changes inside 2020. Now, to go back with carrier approval, if an employer has a fully insured benefit plan, they need to make sure, and Connor Strong would work with employers and plan sponsors with their carriers, on a fully insured basis, a carrier may have issues or concerns with respect to a change in risk. And an employer can't simply do this without making certain, if they are fully insured, that it will not negatively impact their plan. The same is true with a self-funded plan, making sure there are no implications for stop-loss coverage. So, summary here, this is important. This is an optional rule. An employer can keep things exactly as they are now, as it relates to mid-year changes, or adopt these rules to allow in-year, in 2020, flexibility, so long as the right checking has been done either with fully insured plans or with self-funded plans. And of course, this would require a cafeteria amendment to be made not later than the end of next year. And as of now, this rule applies to all of calendar year 2020. So a little bit further on this permitted mid-year changes, again, optional. So 2020 mid-year for health FSA and dependent care accounts, an employee can make a whole new election. They can decrease or increase the existing amount on a prospective basis for whatever reason they have. It's entirely at their discretion if an employer or plan sponsor adopted this. They can also revoke an election they've made. Now, employers can choose to limit the revocation or the decrease to the amounts no less than the amounts already reimbursed to the employee, which obviously makes sense, and it helps avoid potential losses from an overspent health FSA. If an employer was to allow this to happen, again, it's optional. Similarly, plan needs to be amended. Again, this applies to 2020, and it would, of course, require coordination with your administrator or TPA that manages the health FSA and the dependent care account. So another option available to employers and plan sponsors. So the last item I'm going to cover before I turn it over to Phyllis are FSA changes. Again, real important. These are optional things that an employer can elect to do. So extended claim periods. So for amounts that are unused, that remain in a health or dependent care account, FSA if you will, as of the end of the grace period or the end of this year, what can happen? Well, the cafeteria plan could allow employees to apply those unused amounts to pay for, reimburse expenses under the FSA that were incurred through the end of this year. So this is optional, that in really providing the participant to use unused dollars over a longer period of time, recognizing they may not have had the expense. And then the increased carryover amount, an employer can amend their health FSA to increase the carryover, optional, from $500 to $550 for carryovers from a plan year that started obviously this year, 2020, can be carried over into 2021. So you can see a plan amendment must be adopted by the last day of the plan year for amounts to be carried over. And again, optional. So an extended claim period, you can see here the extension of what that might look like optionally speaking, and then the ability to allow a participant to roll over more dollars than they would otherwise. And again, in order to do this, a plan amendment for the FSA would need to be adopted, and we and/or an employer plan sponsor's FSA administrator can help walk an employer through those items. So with that, I'm going to turn it over to Phyllis Saracini. Those that are regular participants in the webinar series that we do know that Phyllis is a managing director and leads our compliance practice here at Connor Strong. And so I'm pleased to turn it over to Phyllis.
Thanks, Joe. So I'm going to spend a few minutes reviewing some of the new changes to COBRA and HIPAA and their related election periods. And then I'll also address some ACA rule considerations. And after a few slides here, I'll send it back over to Joe to finish us up. So one area to be aware of is related to the additional time employers have to furnish certain required notices and disclosures, and also the additional time employees have to take certain actions specifically related to COBRA, HIPAA, and benefit claims. So Joe talked about the public health emergency and mentioned that the public health emergency is set to end on October 23rd. That public health emergency will then be followed by this new concept, which is an outbreak period. So the outbreak period basically provides an extension for another 60 days after the end of the public health emergency. So that brings us all the way to the end of the year. And then the normal election rules that apply for HIPAA and COBRA come into play. So one of the extensions during the outbreak period is related to furnishing disclosure notices. Employers have to act in good faith to furnish these. So you're getting some extra time, but you still have to furnish them as soon as it is administratively practicable. Although you do have until the end of the outbreak period to get these notices out. So employers should keep records of any delay in providing notices, and also keep records of your good faith distribution efforts. And then those efforts can include taking advantage of electronic distribution options if the employees have access to email, text message, employer websites, and the like. And these notices and disclosures that apply are things like SARs, SPDs, and SMMs. And I have a couple slides here. These are really just review. Nothing new on these slides. It's just sort of indicating you have summary plan descriptions, what the normal deadline for those are. Then you have summary of material modifications where you've made a material change to benefits and the normal time limits that exist there. And then, of course, your summary of benefits and coverage. These particular notices are subject to this extension for good faith reasons. And then one more slide on a couple other notices that this rule would apply to. That would include the Children's Health Insurance Program notice, the Women's Health and Cancer Rights Act notice, and then the summary annual report that applies with respect to 5500 deadlines. One thing to note is there was an earlier deadline this year that applied for Form 5500s. During the worst period of the pandemic, March, April, May, there was an extension for certain filings due during that period, but there is no extension for the deadline for our many calendar year clients who has forms originally due July 31st and may have had an extension through October 15th. So those normal rules continue to apply. Gotcha. So due to COVID, employees are allowed more time to take certain actions related to a couple different areas, COBRA, HIPAA special enrollments, and benefit claim periods. So plans basically are required, this is not optional, are required to disregard the outbreak period in determining whether employees meet certain deadlines. So for example, COBRA options have to be kept open from March 1st through 60 days after the end of the outbreak period. And then at that point, the normal COBRA deadlines would resume after the end of the outbreak period. So COBRA deadlines are extended for a couple different purposes. There's multiple COBRA deadline issues that arise as someone goes through their COBRA election process. So for example, the 60-day election period this applies to, the 45-day initial premium payment period, and the 30-day grace period for subsequent premiums, as well as the 60-day deadline for providing notice of a qualifying event or for the employee to provide notice of a disability determination. The extended rules apply to all of those deadlines. It also extends the deadline for an employer to actually provide the initial COBRA election notice. So I have an example here with employee Pat, who gets a COBRA election on April 1st. And due to these extensions, Pat has until February 20th of next year to elect COBRA, which is really an amazingly long period of time. And then also has an extended period to pay the premiums related to that period of time. And of course, nothing prohibits an employee from electing COBRA immediately, which many employees who want COBRA will do. They can go ahead and elect it immediately, but they can also choose at that point to defer their premium payment until after the outbreak period.
Gotcha. Sounds like Pat's got a lot of decisions to make, Phyllis. Poor Pat.
Following deadlines are also extended during the outbreak period, and these are claim related. So the deadline for filing a claim, deadline for an appealing an adverse benefit determination, and for requesting external review. Also, the rules extend the deadline, the 30-day, 60-day period deadline for requesting HIPAA special enrollments. And these are people think of these as cafeteria status change events, but they're really different. HIPAA is a required change option that employers must allow. So the rules are basically saying for those HIPAA special enrollments that are specifically related to like new babies and marriage, you must allow these extended deadlines to apply. So your normal cafeteria plan limit rules, you can't apply to those particular events. So new rules also temporarily extend claim procedures. So employers must accept delayed filings of claims. And some miss this because health FSAs are subject to ERISA claims procedures. These rules actually apply to health FSA claims that are subject to the claims procedure rules. So, for example, if a health FSA claim runout period for 2019 claims expired March 1st, you get that couple month runout period to submit your claims. Because it expires on or after March 1st, employees have to be given additional time to submit the claims. So it's very important for employers to work with their FSA TPAs and their TPAs in general to ensure that proper administration is occurring with these delayed deadlines. So as to COBRA tolling periods, it's important to note that these new extension rules still allow plans to be designed to pend claims until satisfaction of the election or a premium payment requirement is met. And then the plan can retroactively pay any claims back to when COBRA eligibility was triggered, or the plan can pay claims during the tolling period if it's designed that way, and notify providers that the beneficiary is covered, but the coverage may be retroactively terminated if the beneficiary ultimately does not make timely payments. So this is a lot to put on one slide, but it really has to do with what happens during that period of time when Pat has his election notice and he's out there incurring claims. And this could be very specific to how your plan is designed. And an important note here, we've had these questions come in. There's absolutely nothing that allows a person who's currently on COBRA to extend their COBRA time period. So nothing here says, I'm in an 18-month COBRA coverage period, I'd like more time, and I'd like to elect more time. The rules do not allow for that. So more on the tolling process, the point here again is that the employer should consider the process they're going to follow during the tolling period. And it's important that the COBRA coverage cannot be terminated during that period for non-payment. So all missed payments will be due following the end of the tolling period, and if the payments are not made, then you can go back and retroactively terminate the COBRA coverage back to the original period for when the payment in full is not received by the extended deadline. So lots of issues here to keep in mind. Really want to work with your COBRA administrator. Let's go to the next slide. Okay, so these extensions are going to require adjustments to your COBRA and HIPAA procedures. So it's important that you're in contact with your COBRA and enrollment vendors to understand how they are implementing these rules for you. Note that the vendors may have different interpretations, so it's important to have that conversation and understand what they're doing in order to have your plan meet these requirements. It's also important, obviously, how to communicate this to employees. And there are some DOL online resources. The DOL issued an FAQ that you could provide to participants that sort of broadly overviews these extended periods. Pretty complicated, hard for people to understand just generally how this works, but it's really important that the plan understands that they have the obligation to offer these extended time periods. So on the updated COBRA forms, so the government, we know they like to occasionally update their model forms, and they've recently done this for the COBRA forms. So they've recently updated the model COBRA general and election notices, and what they did was, for the most part, the notice has been left as it was, but they specifically updated to include information about Medicare in the notices. One important note, there has been some class action activity with some wise legal law firms going after large employers alleging technical violations of COBRA notice language. And they're causing some trouble for certain of these large employers around whether the election notices and the general notice really includes the proper language. And if it doesn't, they're making some problems for these employers. So it's really important that you review your notice, understand how the rules have been changed and how the language has been changed, and understand the notice obligations and make sure your process is correct against how COBRA is designed. So the agencies revised the model notices to provide additional information, as I said, specifically addressing the interaction of COBRA and Medicare. Everybody knows how complicated Medicare can be. And it often causes quite a bit of confusion. Let's see. And again, as I said, that really get with your COBRA vendors and make sure you're clear on how all of this is working. Okay. So my last issue here, before I turn it back over to Joe, is ACA. Can't have one of these compliance webinars without talking about ACA. So unbelievably, ACA has been with us for 10 years. I have a few slides focused on ACA and what's been eliminated, what's still in existence, and what might be coming next. So first, what's been eliminated. So since 2010, we've seen a few things repealed, thankfully. The Cadillac tax, the fully insured health insurance tax, that's a 3% tax. And of course, the federal individual mandate was eliminated last year.
One comment to add to Phyllis's slide on this particular page, which is important, is that while the federal health insurance tax has been repealed, this is noted on the slide, some states have begun to re-implement it. Among those is the state of New Jersey. So while this roughly 3.5% tax went away from a federal perspective, the New Jersey legislature and ultimately signed by the governor, adopted a law that in essence reinstates that tax. And I mention it because obviously we have a number of New Jersey fully insured employers and plan sponsors that are going to get hit with this tax. It will come back online again, or will stay in effect in essence as of January 2021. And it again really speaks to the notion of why many employers need to revisit their funding approach to potentially not have to deal with the reemergence of this very costly tax.
Yeah, so just a final note on that. The federal individual mandate, which is different from what Joe was just talking about, that's the, we all individually no longer are required under federal law to have health insurance, right? So no penalty applies to us. But similar to New Jersey with the health insurance tax, New Jersey also decided to institute an individual mandate in the state of New Jersey. And along with that comes filing requirements, somewhat similar, along the same idea as what you're doing federally, but not quite exactly the same. So you need to be careful with how you're reporting to New Jersey for your New Jersey residents on this New Jersey individual mandate. And this slide is really just sort of starting with 2017 when they announced they were getting rid of the federal mandate, and then what's coming as far as different states instituting their own state individual mandates. And again, from the employer perspective, you have no obligation from the state perspective to provide the benefit. So there's no employer mandate to provide the benefit in these states. The only thing that applies to an employer is to report whether you're offering coverage to these folks in your state.
So Phil, as an example here is an employer that operates in 15 or 20 states. In addition to the federal reporting obligation, as a result of this state action, they may have additional reporting to comply with on top of the burden they already have.
That's exactly right.
Okay.
Yeah. And you should be reaching out to your ACA vendors to ask them how they will be assisting you with meeting these state requirements. It is not as simple as them sending a packet to the state that's the same as what they send to the federal government,
Great.
Unfortunately. Okay, so what's still intact? So this slide is a quick guide as to what is still very much in place under ACA. So there are still premium subsidies. There is still the option for exchange coverage. Medicaid expansion and the different rules under ACA continues under ACA. Pre-existing condition protections continue. Coverage for children to age 26. Joe mentioned Medicare loss ratio, the MLR rules. They very much continue. Unfortunately, the 1094 and 5 reporting to the IRS continues. The IRS just issued drafts for next year's reporting. We'll be issuing some updates on that as they issue the finals. And then, of course, the ACA employer mandate also continues. That's the affordability, minimum value, all those fun rules. This is a quick flow chart one of my colleagues prepared, very helpful. Hopefully, this is not unfamiliar to you. It's a quick reminder of how the mandate works. It's been around for quite a few years, and it indicates when you may or may not potentially be subject to penalties depending on how you decide to offer benefits to your workforce, ACA full-time people, part-time people, and so on. So hopefully this is familiar content to you, a nice slide to print and have available as a reminder. Okay, so we always get questions on look-back measurement methods. As a result of COVID, absolutely nothing has changed about how all this works. So the IRS has not issued any new guidance dealing with employer shared responsibility rules as COVID affects all of this. So the general rule for determining full-time status continues to apply. Hours of service has to be counted during the measurement period. The time an employee is paid for time working or not working is counted. Special rules for unpaid FMLA leave. All the normal rules are going to apply. And full-time employees who are actually determined to be in a stability period have to continue to be treated as full-time as long as they're employed. So all those rules continue. And my next slide just deals with an actual participant question we got on, geez, what do I do with these furloughed, laid off people with respect to my 1094 and 1095? So we all know these coding issues on the forms can be very tricky. As a matter of fact, the new form version that the IRS is about to issue, when you see our update that comes out, we will address the fact that the IRS has added even more codes to this form, and the codes are just really tricky. Generally speaking, furloughed employees aren't going to be considered terminated employees. So, perhaps you're coding 2B, employee not full-time for these folks, and not 2A, which would say that the employee, the person is no longer employed. If you're using the look-back method to determine eligibility and the employee was considered full-time during the furlough period, the employer may want to use the applicable safe harbor codes on the form for each month during the furlough period. So the real crux of this is you're going to have to carefully consider how to report the status of these workers depending on what's actually going on with them and how you're determining eligibility and how you're running the look-back measurement periods. And of course, this can all be critical as IRS penalties can be significant for how you're filing and providing information during these periods. There's a lot of exceptions, a lot of special circumstances relevant when you're adjusting these reporting rules. So you should really be, consulting with your ACA vendors, those folks who are helping you actually fill in these forms to make sure they understand how these rules work and that they're addressing them properly. And my last slide, what's next? So the biggest what's coming next is related to this ACA case that's on appeal to the U.S. Supreme Court. So this case is related to the 2018 ruling that found that the entire ACA was invalid because they eliminated the individual mandate. So this ruling obviously results in quite a bit of uncertainty about the future of the ACA. So the United States Supreme Court has decided to hear this case. Arguments on the case, curiously, are set to begin in mid-November, just after the presidential election is over. And then the final ruling, we will not get the final ruling until June of next year. So in the meantime, all existing and current ACA rules, including insurance mandates, employer mandates, related reporting rules, are going to continue as is. So that's it for me. Back to you, Joe.
So what's next? Wow. As we look forward, what's next? I think we all hope that 2020 comes to a conclusion as quickly as possible based on the events that everyone has experienced. But there are some things that are still on the radar. So in addition to the myriad of things that we had to share with you, that we had to make sure that you were conscious of and aware of, there's other things that may still be coming. So there could very well be subsidies in a round of COVID relief to help people pay for COBRA. That's been debated and talked about quite a bit. It's not made either of the first two iterations of the Relief Act, but there could be subsidies for people to continue to take COBRA in the event that they're laid off and they're furloughed and they don't have the income to pay for coverage. There could be further relief around more to do with balances in one's FSA. With the drop in healthcare expenses, people have money in their health FSA that has probably been unused, and there's concerns about that being lost. And there is some sense that more relief could come with respect to carrying those balances into next year because of the pandemic. ACA reporting and relief. Will the federal government understand that employers have been shut down? They've not been able to operate as they normally would, and the tremendous burden that comes with this reporting issue may be only more complicated as a result of the pandemic. We're rooting, obviously, for and following very closely those issues around reporting relief. We do think that there'll be more enhancements, especially around behavioral health, with regard to telehealth. People have seen that telehealth can work. This may be one of the lasting effects of COVID, is that people are able to engage telephonically or via Skype or otherwise with a provider, and maybe some of the enhancements around accessibility could be made permanent. There could be more guidance around return to work employer initiatives. There could be more federal aid. There could be more relief on the paid leave requirements that extend into 2021, or there could be an expansion to include the large employers, those with 500 or more that are not presently obligated to comply under what has been passed so far. There is something else that is worthy of mentioning that has withstood court challenges thus far, and that is the Trump administration's push for hospital transparency. So as it stands right now, it's gotten a little bit of press lately. Every hospital in the United States will be required to put on their internet the amount of what their compensation arrangement is between themselves and the insurance companies, which could mean the disclosure of all the discounts and arrangements between the health plans and the hospitals. It has withstood at least one court challenge thus far, and it appears as this will happen. Hospitals are obviously scrambling to be able to comply to put the data on their website in a meaningful way. This could really rip the Band-Aid off the transparency issue. So it's something that we're watching very, very closely around hospital transparency. There could be a further ease around the application of deductibles under a high deductible health plan for people with chronic illness. Today, under the law, with the exception of the special rule, deductibles have to get met first unless it's preventive care. Well, what do you do for a diabetic or someone that has COPD or CHF or other chronic illnesses that's in a high deductible health plan? We don't want them to be prevented from getting care. Maybe there is a modification for those chronically ill to allow to use some of their dollars pre-deductible. And then, of course, there's lots of conversation around the continued elevation of how benefit offerings for the LGBTQ employee community will comply as it relates to federal sex discrimination protections under Title VII of the Civil Rights Act, how employers may be able to assert religious or even moral concerns with respect to contraceptives. Those two issues around the civil rights impact and some employers having religious and moral concerns around contraceptive continue. And executive orders and so forth may not be the permanent answer to how some of those things get adjusted. And there's ongoing litigation on many of these things and certainly uncertainty. And frankly, some of this may very well be resolved as we get into the election, and whether a new administration moves in a different direction or whether the current administration continues on the path that they are on. There will clearly be more changes coming next year as a result of whoever occupies the White House. And we will certainly continue to provide updates and new materials and information and regulatory bulletins and do more webinars like this. We do want to remind you that there are a number of very, very useful resources that are updated regularly, some of which are not even benefit applicable, that we think are helpful for employers to be able to use and to be conscious of. And we've listed them here, and when you get the deck, you'll be able to certainly use and confer on them. And then, of course, at the Connor Strong and Buckaloo corporate homepage, we have an entire section devoted to anything and everything related to COVID, how it impacts employee benefit plans, how it impacts property and casualty plans, and we will continue to provide updates. We understand that today's session was particularly technical. lots of detail, but regrettably, that is the world that we live in right now, and it certainly is our obligation to keep you abreast of these ever-changing developments, and our team here at Connor Strong will do everything we can to help continue to demystify these things and help you navigate through them. So certainly on behalf of my partner and colleague, Phyllis Saracini, and all of the associates at Connor Strong and Buccaloo, we appreciate your business. We appreciate your time. We wish you all the best as we continue to navigate through COVID, and we look forward to opportunities to talk about compliance things and other topics as we look forward to the new year that perhaps move us in a new and a better direction, certainly as it relates to the pandemic. Thank you again for your time. We hope to see you all real soon. Have a great rest of the day. Bye-bye.